You need some additional time to prepare?
Yes, sir.
I'll give you some additional time to prepare your sovereign citizen argument. When do you want to come back?
Next matter is State of Kansas versus Gordon Cooley. Case number is 24TR65. Are you Gordon Cooley? You'll need to unmute your screen, sir.
Yes, I am the man that is that person.
So you're Gordon Cooley?
Yep.
Very well. State appears by Jill Gillette, County Attorney. Mr. Cooley, there's been an amended complaint filed on, it looks like April 17th. You're charged with driving while suspended as a second offense for on or about March the 25th of 2024 in Elk County, Kansas. If indeed you have a prior conviction where this would be a second offense, that's a Class A misdemeanor. A Class A misdemeanor is punishable up to 1 year in the county jail and a fine not to exceed $2,500. Additionally, with a second offense for driving while suspended, there's a mandatory 5-day minimum sentence. However, a person can be placed on probation from that, but there is mandatory sentence that would have to be imposed. Do you understand what you're charged with?
No, I don't quite understand those very.
Buckle up, guys. Today we're diving straight into a courtroom roller coaster. Right from the start, we're introduced to two sovereign citizens making the critical mistake of underestimating the law. Kansas kicks things off with confusion, denial, and high drama as the defendant refuses to understand even the most basic charges. This clip sets the tone perfectly, showing how reality collides with fantasy, and the viewer instantly knows chaos is coming.
Well, I think this is a matter of a mistaken identity. My persons was never involved in anything. I'm carrying my property from point A to point B. There's no vested interest of the state to even stop me. I'm exercising my God-given constitutionally protected rights, and I stated that to the man acting as the police officer. I didn't present him with a license.
You are charged, sir. Hold on. You're charged with driving while suspended, a second offense. That would indicate to me that you've had a first offense.
No.
So have you been in court before on this type of charge?
Nope, not on driving while suspended. No, I have not.
All right. Well, that is what you're charged with. You don't have to agree with it. You can certainly, that is an issue at trial if you feel you have a defense. As with the others that I've explained, you have certain rights. You are charged with a misdemeanor, so you are entitled to be represented by a counsel. And if you wish to apply for court-appointed counsel, if you meet the financial guidelines, I would appoint one to represent you. You also have the right to represent yourself. You also have the right to have counsel of your own choosing at your own expense. So at this time, if you wish to have a trial, if you wish to speak with an attorney or counsel, would he qualify under any programs you have since you charged this as a second offense?
No.
All right. So apparently diversion wouldn't be an option for you. So if you're wishing to have a trial or to speak with an attorney, your plea at this time should be not guilty. If you wish to plead guilty, then we'd proceed to sentencing. But based upon what you're telling me, those would be issues that could be addressed at trial. So at this time, how do you wish to plead?
I don't plan to plead. I guess I'll answer in affirmative if Demers is not acquiesced.
All right, guys. Watch as the Kansas defendant doubles down on his sovereign citizen rhetoric, refusing to enter a formal plea. The tension rises as the judge calmly navigates procedural rules while the defendant spirals into absurdity. Every line of word salad highlights a clash between logic and delusion, showing how easily courtroom reality can crush a fantasy argument. This is a masterclass in patience under pressure from the bench.
Enter a formal plea, you're standing mute, and I will enter a plea of not guilty on your behalf.
Okay, I exercise my right to trial by jury then. I'd like to face the man or the woman that claims I've done them harm or loss.
Mr. Cooley, if you wish to have a trial by
I'm
jury.
Gordy. I'm not Mr. Cooley. I'm Gordy. I'm a man. I'm not a person.
All right. Mr. Cooley.
Can I ask you a question,
Cooley.
sir?
You need to be quiet for a moment. I'm going to explain what the situation is. You have the right to be represented by counsel. You entered a plea, refusing to enter a plea, which is fine. A person can stand mute, and I will set this matter for trial. If you wish to be or have a jury trial, you have the right to do so. However, you need to do that in the proper form. With a misdemeanor offense, you have to file a written motion for that request. Otherwise, it's set before the court. So you would need to do that in a timely way. If you're going to represent yourself, you would have to follow the rules as though you're an attorney. So all of those things would, most people don't have the training to where if they're going to do a jury trial, they're better off being represented by counsel. But that's a choice that you're going to have to make.
Okay, can I ask you a question?
Yes, you may.
Can there be a valid cause of action without an injured party?
Sir, that's not a valid question for what we're doing here today.
I've tried settling this matter in the private twice. If you have any papers in front of you with my signature on them, it's because that is what was required for me to get away from.
Now, things get truly intense. The defendant calls the officers captors and demands validation for his made-up rights. But the judge executes precision control. Each moment builds suspense as the court date is set and the defendant is methodically dismantled without raising the judge's voice. This clip perfectly demonstrates the power of procedure and composure over chaos. And it's a highlight reel of sovereign citizen failure.
If you're going to apply for a jury trial, then you'll need to make that application by that time. Otherwise, you'll be set for a bench trial. That's before the court. Sarah, could you give us a date, please?
What sort of time frame would you like, Judge? 30 minutes?
Approximately 30 days, 30 minutes would be fine.
We can do May 15th at 2:30.
Judge, I'm out that afternoon. We could do 11:30 if there's nothing else scheduled there.
We put that for a trial and for an hour, didn't we? So
If you only need 30 minutes, we could do the 11 to 12.
well, we said something at 10:30, I believe, or was it the 10 o'clock that was set for trial?
It was the 10:30 to 11:30 that was set.
Okay, let's set this at 11:30 for a pretrial. So, Mr. Cooley, you will need to appear at the courthouse in Howard. And if you're going to file a motion for a jury trial, you need to have done so by that time. If you're going to hire an attorney, you need to do that. If you're going to apply for an attorney, I would suggest that you do that as soon as possible, so that you can have counsel at that time.
Am I going to be able to face the man or the woman that has a claim before me, or are you going to discharge the matter? If there's not a man or a woman here, then this matter needs to be discharged.
Sir, I've heard these arguments before, and those are not legal arguments. Somebody's made these things.
I'm not a member of the legal society.
Sir,
Can you bring the law to the court, please? Can we bring the law to the court?
Mr. Cooley, stop interrupting. At your hearing, if you have motions that you wish to have heard, you can file them in advance. I would strongly recommend you be represented by counsel. But your court appearance is May 15th at 11:30, and you are to be here in person.
I will.
Here comes Florida, and it's a whole new level. The defendant attempts to wield the 14th Amendment in the UCC, one like weapons, but flounders under scrutiny. Every question exposes ignorance, while the judge systematically breaks down the arguments with surgical precision. This clip is both cringeworthy and mesmerizing, showing firsthand how confidence without knowledge meets instant courtroom reality. The tension and suspense here are electric.
Good morning.
Good morning, sir.
How you doing this morning?
I'm well. How are you?
Fine.
Morris had previously, it was one case that I was already representing him on. I don't know that we ever got one on this most recent charge. Okay.
Let me see.
Mr. Morris, I know Mr. Hill was representing you in the 23-174 case. You're here for an arraignment on the 24 CF49 case. Has your financial circumstances changed?
No, sir.
All right, I'm going to appoint the law officer Henry Mark Sims to represent you in the 24 case.
I go state this up.
The aftermath is brutal and deliberate. The Florida judge gives a clear warning, showing patience but holding the defendant accountable. We witness a rare blend of wit and authority as the sovereign citizen is sent back to regroup, while the judge ensures he fully understands the consequences of his claims. This is a short but incredibly potent clip that reinforces the theme. Preparation matters, ignorance does not.
I'm not real sure what Mr. Morris is trying to claim in that writing right there. Said he's not a citizen.
Finally, we reach the climax, sentencing. Tension spikes instantly as the victim refuses to attend, and the defense pushes for a deferred conviction, only to hit an immovable wall when the prosecutor objects. The defendant compounds his troubles by writing a shocking victim-blaming statement, and the judge does not hold back. Probation, jail, and real consequences collide with arrogance in a courtroom moment packed with suspense, accountability, and a reality check viewers won't forget. At the end of this video, if you enjoyed this breakdown, don't forget to like the video, subscribe to the channel, and hit the bell so you won't miss any upcoming courtroom chaos. We'll see you in the next video.